Then comes this outline of a scheme for legal aid to the poor. So, this is a scheme that was brought by the central government in 1960. This scheme is mainly aimed at providing legal aid to the poor. As the name suggests, it is called as Outline of a Scheme for Legal Aid to the Poor 1960. It clearly specifies three things. Number one, the facilities to be made available under the legal aid. Second, mode of functioning of the legal aid. And third one, the source of financial assistance. So, these are the three things that was clearly specified in this scheme. And the scheme clearly laid down the following things. Number one, what is the professional assistance you should be given? It talks about the remission of the court fees, processing fees, substance and traveling allowance for the witnesses, and it also talks about free certified copies of the judgments to be given to the litigants, and free preparation of appeal paper books, including printing, translation of documents. So, that means for the first time this scheme gives a detailed list of what is entitled under the free legal aid. And it also proposed for the constitution of three different authorities. That is to say, the state legal aid committee, the first one at the state level. At the district level, the district legal aid committee is the second one. At the third level, that is the local level, the taluka or tahsil legal aid committees. So, all these three committees are supposed to provide legal aid both in civil as well as criminal cases. And the most notable contribution from this scheme is that for the first time it provides three tests for eligibility to claim a legal aid. That means it is not that everybody would be free to get legal aid, they need to satisfy three things. Number one, the first one is the means test. As the name suggests that the first qualification for the person to claim legal aid is that his inability to pay for the legal assistance, and that inability to pay for the legal assistance is due to poor financial resources. The second one is prima facie test, that is whether there is an existence of prima facie case in favor of the petitioner who wanted to file a case but unable to file a case because of want of financial stability. The third one is the reasonable test. The reasonable test says that for protecting the interest of the justice, is it reasonable to file this particular case? If the answer is yes, then yes, the person is entitled for legal aid. So, he has to clear means test, he has to show that there is a prima facie case in favor of him, and the third one is that it is reasonable to file such a case to get the justice for him. And for the first time, the scheme also talks about giving a statutory force for this legal aid scheme. That means till now the legal aid is going to be like any other scheme of welfare schemes, but for the first time it says that this may not be sufficient, better to give a statutory force. And it also said that every legal aid committee should have an office, and this office should be open during the entire office hours. And further it says the period for which an application for the legal aid remains pending before the legal aid committee shall be excluded from the computation of the period of limitation, as a very, very important recommendation, because as we know that every litigation has a limitation period. However, counting that litigation period, the period that this application pending before the legal aid committee would be excluded. So, that gives a lot of leverage for the poor people when they are approaching for the legal aid committee for a free legal aid. And it also proposed for creation of legal aid fund in every state, because one of the problem that we are facing is that there is no financial support for these legal aid schemes, and the government is not in a position to provide financial support. So, it proposes that legal aid fund in every state should consist money received from the state government, grants received from the central government, contribution made by partially admitted persons. It also involves the cost that is awarded by the court to the opponents, and fee also received from the legal advice, and also it says that even a private donations can become part of the legal aid fund. So, it is a very good suggestion that each state should have a fund for it. And the suggestion of this committee, but unfortunately, though it talks about how the finances should be raised, but it has the same fate as the other reports and other recommendations, as it could not be implemented due to financial inadequacy. And this, even though the central government tried to provide some financial assistance to implement this scheme, unfortunately a financial emergency was declared during those days due to the Chinese aggression. Hence, this is not materialized. So, as a result, all these important recommendations of this scheme is remained on paper still today.